This is Hap May with the Legal Play.
And I am Chelsea El-Azzi, Hap's associate. Hap, today I want to talk about settlement agreements.
Good. What are we settling? Which is
many
one of the first questions you need to ask. What is it you are settling?
Yeah.
In the process.
So the podcast that we had and the blog page that we came up with before this one was specifically focused on finding yourself in a financial strait with someone that you may have gone into a deal with, and
or some sort of financial arrangement. Yes,
right. And often settlement agreements have to do with money. I mean, a lot of it has to do with money.
A lot of money. Not all of them, but most of what we lawyers deal with has to do with somebody wanting money from somebody else. Mm-hmm. In the process,
or wanting something.
Yeah. I mean, there's sometimes child custody arrangements don't necessarily have money involved in it, but whether you get them on Tuesday or Wednesday is something.
Except you can't really do like a private settlement agreement with child custody.
You really can't. But those are arrangements, or sometimes I've seen that. I mean, with pets you could do it. I've seen divorce arrangements with pets that the who gets the dog on the weekend. I mean, that's but those and I don't deal with that a lot, but there are those situations as to that sometimes in the elder care issues we have, who's going to take care of mom, and who's going to take her to the doctor, who's going to take care of her financial accounting, and some of those are things that are non-monetary that people.
Well, and I did one recently where there were some collectibles where someone had passed and they had I won't say what, because I don't want, but I don't know. I mean, they might have had some monetary
that was
value.
it, and that's smart. I mean, it could be it's either something that has money or perhaps property. Who gets the house? Who gets the farm? I mean, those are
in this case, it was it might have been the money, but what was being thrown around was the sentimentality of the objects, and
those are always tough.
Yeah,
those are always tough because what we think is rational, but we think is rational, or not being rational is something that can be very important to one of the parties.
Right. So let's back up a bit. Like, what gets you to the point? What gets parties to a point where they may need a settlement agreement?
Well, there is some dispute.
There is some dispute,
or a potential that there will be a dispute that they want to resolve before that dispute becomes some critical or could do serious damage to the business or a person or the arrangement or something to that effect. That's when it is where there needs to be, or there is a potential for there to be some dispute.
Yes, and sometimes a lawsuit has already been filed. Someone's gotten so angry that they go ahead and file the lawsuit. And then the other party's like, whoa, I don't really want to do this in court. Can we talk on the side and, come up with a settlement agreement of some kind?
And there are that's because of the advantages of some of the settlements. A lawsuit tends to bring out a lot of public information, a lot of and decisions that juries or judges make, are set there in stone and out there for the public to review, where with a settlement agreement, the parties can agree to things, not put a bunch of stuff in the public domain, not expose themselves to a long drawn out litigation process, and come to a settlement.
Right.
Which is generally desirable.
And I mean, a settlement agreement is exactly kind of what it sounds like. It's terms that the parties agree upon. They're written out and everybody signs their names, potentially maybe even gets it notarized depending on what the circumstances are. And there you are. There's a piece of paper, there's a document that says we have come together, we understand these terms, and we agree on them. And it's like a binding contract.
It is a binding contract, in fact. And in fact, a lot of the litigation, not a lot, but a good portion of the litigation we have are breaches of settlement agreements. in the process, and that just happened. So it's good to have a good settlement agreement. It's good to have parties that come to an understanding and know what they have to do in order to solve their differences and comply with the settlement agreement.
Can parties create a settlement agreement without the involvement of attorneys?
The answer is theoretically yes. I have seen parties that have tried to do that, and the results are not always good.
I pose this question because I also want to say that I have seen and worked with a client recently that they tried to do it without the involvement of attorneys, agree amongst themselves, draft it up, and I think one of the parties just was like, "Yeah, I'm not gonna sign it." So there was a draft floating around out there.
That was not a settlement agreement. I had a case, one of the worst cases I've ever had, where two parties drafted up their own agreement, and the agreement didn't make much sense. It had contradictions,
Mhm.
and its interpretation took years, blew a sale of a piece of real property as a result of the dispute, and it was just awful.
Yeah.
It really was. It's an, I mean, a good lawyer, experienced, will be able to anticipate what sort of problems there are and discuss it with the parties and incorporate that into the agreement.
Right.
Now
And breaches of the agreement.
and the consequences
I
of breaches of the
Right.
agreement.
I feel like what a lot of people just, non-lawyers most people are looking at the positive and they're anticipating the best outcome. And unfortunately,
Which
in
is
our profession, we are taught to think of all the worst case
we
possibilities.
are doom and gloom pessimists.
And but it's there for a reason to articulate, well, what if this, what if this, what if this? Okay, then you both agree in this case scenario, then this, then this, then this.
Right.
So if there's a breach of the agreement, the other party knows exactly what steps they are allowed to then start
And what
engaging.
sort of penalties there are.
Mhm.
Perhaps there's some sort of collateral to ensure performance of one of the parties in the process, and a breach of the settlement agreement would allow the non-breaching party to foreclose on some collateral.
Yeah.
Um,
And I love what happened with our case recently. A lot of people out there don't know the specific statutes that support their rights and things, and you were able to kind of look at what the dispute was about and say, oh well, you know under Texas property code, da 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 da, here's your right specifically, and if you articulate that, I think in writing, specific rights
that was correct.
supported by law and especially statute, that's
And if
strong.
we're talking about the case I'm thinking about,
Yeah.
I mean, it was really, there didn't need to be a settlement agreement because the law was there, and if they tried it, they would lose.
In
So,
this case, we were trying to avoid litigation
right.
because it's timely and it takes time. It's time consuming. It's costly and
Mhm.
just generally a pain in the butt.
Yes, yes.
And in this case, the parties had drafted a bunch of things, which we ended up taking, but we fleshed it out quite a bit, and hopefully,
Yes.
they're running with it and seeing it
And it
through.
does. And the settlement is a whole process, which we've kind of gotten into just kind of the edges of what is a settlement and what needs to be done. But there is a process. There is a dispute. The parties raise the dispute, either in litigation or not. Then they have to decide whether they want to try to settle it or figure out what they do if they don't settle it. And there's some disputes people have that they can just dispute and go on their merry ways and not really have any consequences from not being able to agree upon something. That doesn't generate a lot of business for lawyers. What generates business for lawyers and creates heated disputes and litigation and things like that are things where the parties have to have a resolution.
Yeah.
Whether that is through litigation or whether that is through some sort of settlement in the process. Conceivably acquiescence by one of the parties, but that's generally not desirable. One party gives up and
Right.
doesn't.
And the ones that I've helped negotiate, I always try to find a middle ground where, both parties can find something to be satisfied with in the agreement.
And
If
some,
we haven't already,
sometimes that's the case, and sometimes people come into disputes with different bargaining positions. The law in the one case we talk about, I mean, favored our clients.
right.
A lot of times it's the resolution has to be somebody has to pay somebody some money, and the other party will walk away with the property or the business or whatever it is process. And the rich party, in most cases, is going to have to buy out the poor party if you have that dynamic, where it's okay, there is a house that we both own, either because maybe we had a relationship, or maybe we were siblings, or maybe my father married your mother and then they both died, and now we're step siblings fighting over
Someone passed away, there was no will,
yeah,
and maybe.
who gets the house,
Yeah.
and maybe I have a lot of money and my stepsister doesn't, and my stepsister, and I get into dispute, and one of us needs to buy out the other one in the process. If she doesn't have any money, that's not really something she can do.
Right.
So that's kind of the settlement kind of becomes dictated by the facts.
And some settlement agreements I've seen have been fairly not simple in terms of the wording and all the provisions that go into it, but the issue is pretty simple. There are bigger cases we have had where the settlement agreement is multiple parties, and
Yes.
there was a previous settlement agreement that was broken, and we had to do another one. And I mean that
And that's
things can get messy, and in
Yeah.
that case, there's definitely good advice to bring in a lawyer just to make sure that everything's clean up and sound and everybody's on the same page with what needs to happen.
Right. And so there's, generally speaking, a dispute. Just kind of summarize, there's a dispute. The parties recognize the fact that there needs to be a resolution.
Mhm.
The parties, either through lawyers or theoretically by themselves, come to, an understanding of what the facts and the dynamics are, and what solutions or resolutions are possible.
Does a settlement agreement need to go through court?
There are some advantages to going through court, but no, it does not.
I have seen, I mean, I'm sure this is an entirely different thing, but there are agreed judgments, which I know are
There
like
are
related.
an
They're kind of
an
related.
agreed judgment. Sometimes a settlement involves giving an agreed judgment. I mean, typically, if there's a dispute as to whether you or I own this house, and we come to an agreement that says you will drop your claim to ownership of the house if I pay you $100,000, make up a number. And we sign a piece of paper that says that. Later on you decide, well, that's not good, and you decide, hey, I'm going to claim it, and you go tell the tenant that's in there they have to pay the rent to you. So that's a breach of the settlement agreement, and I have to sue you in order to obtain the enforceability of the settlement agreement. If we were in litigation, we may want to reach that settlement agreement and then have an agreed judgment where the court has found and enters into my favor a judgment saying that I am the owner of the house. And that way would make it more difficult for you to come back and say, hey, it's still my house, I'm still claiming ownership. A title company may have trouble with that, but if I had a judgment, that would be easier for me to resolve. So if I'm going to pay money, so I get title to the house, I may want something more than just a piece of paper saying you agree to that.
Mhm. So HAP has seen this with real estate, trusts,
I've seen,
probate estates.
yes. Yes,
Many.
I mean, businesses, corporations.
Anything that can have a dispute and
Yes,
could
yes.
potentially be settled
And there are some,
amicably.
and there are some
hopefully.
players out there that no matter what you give them, they will ask for something more tomorrow. And the trick in a settlement agreement is to make it so that you don't have to
Draw
give
the
them
line.
anything.
This is the line.
tomorrow.
We are done.
Yeah.
Here are the terms and now we're done.
Yes.
You,
Yeah.
you signed and said this was it.
Right. And you gave up what you're supposed to give up. You know, there's nothing more you have to do to perform.
And having a lawyer there to make sure you've drafted all that language in place is a very, very good idea.
Yes, yes. And frankly, making sure the other party has a lawyer as well. Because you hear all the time excuse, well, I didn't know that because I didn't have a lawyer.
There are waivers that you can
But
put in
that-
an agreement that says, I knew my rights to get representation and I chose not to.
And that helps. That helps. Although you hear that, well, I didn't understand that because I didn't have a lawyer. You know, so there are some deals that we will not advise our clients to enter into unless the other party has a lawyer. So I want to take away that excuse when that other party decides to breach or ignore the settlement agreement.
Okay, lots of good things.
All right.
All right, thanks, Hap.
All right. This is Hap May with the Legal Play.